I've had a lot of questions coming on the YouTube comment section about intentional homelessness, and so I'm going to try my best to do a video which hopefully covers all of them. Intentional homelessness is quite complicated in some ways, but as we'll find out as we go through, it's actually quite difficult to be genuinely intentionally homeless. Lots of councils will tell you that you're intentionally homeless when actually you're not, so if nothing else, it's always worth challenging. And in order to try and explain this as best I can, I'm going to give two anonymised examples where the question is whether they're intentionally homeless and ultimately what they can do in those situations. So the first example is a mum, let's call her Kelly, and she's got an adult son who's 21, he's got autism and she's his carer. He's got quite significant issues as a result of the autism. And she's also got a younger daughter, let's say she's 15, so she's still a dependent child. And she loses her home through rent arrears, so she falls into rent arrears. We're going to work out whether she's actually genuinely intentionally homeless as we go through, but crucially here, the council has issued a section 184 notification which says she's intentionally homeless. And once you get that decision, once you receive it, you've got 21 days from that date to request a review of that decision. And if you don't request a review of that decision within that time period, it kind of becomes set in stone. It becomes very difficult to then unpick it and challenge it. But there are some ways of doing it, as we'll find out. And the second is a guy, let's call him Joe. And Joe has long-term mental health issues. He's got bipolar affective disorder. He's also alcohol dependent. And he was staying in a supported accommodation scheme, supposedly for people with complex needs. And while staying there, he basically becomes very intoxicated. He drinks too much. He stumbles around the hostel, urinates all in the corridors, gets half naked, and he's evicted quite understandably by the supported accommodation provider because they've got other people to think about. So he's now evicted, he's now homeless, and in both cases they've gone to the local authority. But in Kelly's case, the problem here, or one of the problems here, is that the Section 184 decision has already been reached and she's now outside of that 21-day period to challenge it. In Joe's case, this is the first time he's made the application, so he's basically starting from scratch. And hopefully between these two examples, I'm going to cover quite a lot of ground about how intentional homelessness actually works. Now, if we go back to the basics, anyone can approach the local authority and ask them for help, and if they give the council reason to believe they might be homeless, then they've triggered Section 184. So Section 184, ask the council for help with housing, give them reason to believe you might be homeless, which is as simple as Joe saying, hey, I'm homeless, I've just been evicted, can you help me with housing? That would be a homeless application there and then. It's not in 2 weeks' time when the council has time to see you. The application has happened already. And one of the things you'll notice about Section 184, those two criteria, is that it doesn't mention intentional homelessness. So whether or not you're intentionally homeless is totally irrelevant to those initial duties. Asking the council for help with housing, giving them reasons to believe you might be homeless. And that can be done in 100 different ways. You can make homeless applications to any department of the local authority. The Homelessness Code of Guidance is clear about that. Obviously, you want to go to housing, but often you might be in contact with social services or your local councillor or something like that. And if those two criteria are met, Section 184 has already happened. The next relevant section that the council should be looking at is whether there is reason to believe the homeless applicant might be homeless, might be eligible for assistance, which loosely means having recourse to public funds, and might have a priority need. So in Joe's case, he goes to the council, I've just been evicted from a hostel, can you help me out with housing? So he's triggered Section 184. They should then be asking questions around his support needs, whether he's vulnerable, and also his potential his citizenship, his immigration status, but let's assume he's a British citizen, he's lived here all his life. So the council's then got reasons to believe he might be homeless, reason to believe that he might be eligible for assistance, and through his mental health issues and substance use, reason to believe he might be in priority need. Therefore, they have to immediately place him in Section 188 interim accommodation, which needs to be suitable. That's a topic for a whole different video. And again, you'll notice here that intentional homelessness is not raised yet. It's not relevant to Section 188 at all. So the fact that he's just been evicted from a hostel does not have any bearing on whether Section 188 is triggered. Once he's then in suitable temporary accommodation, the council can then start looking at things like local connection and intentional homelessness. But even if on day one they realise he is definitely intentionally homeless, they can't issue a Section 184 decision until the 56-day relief period has finished. They might say to him, look, we think you're intentionally homeless, bear that in mind when you decide what you want to do now. It may be we don't have a long-term duty to you, but they can't actually issue that decision until day 57. And on day 57, even if he is intentionally homeless, even if he genuinely is, the council will still have to house him for a period of time that gives him a reasonable prospect of finding something else, which is typically 28 days, but you can argue that it needs to be longer. If in Joe's case, he's already been barred from all the hostels in town, for example, and he's got no money, and there's no obvious way how he's going to get housed within that period, so you can ask for extensions on that period. So he's in temporary accommodation. The council can then, as I say, start these inquiries into why he lost the accommodation. And in order to explain this, I'm going to use a template from my local council, Bedford Borough Council. We basically did a freedom of information request and got all of their template letters that staff use. Actually, as part of a bit of work we're doing to try and get the templates to be improved so that it actually helps staff make a good decision. But the example I give here in the template they've got is actually reasonably good kind of breakdown of the logics of whether someone's intentionally homeless. So again, if you're a lawyer, you might argue some of these steps. You might say that they're actually a little bit off what the law actually says. But loosely speaking, they do cover what needs to be asked. So if I go through them now, I'll flash them up on the screen. And I'll go through these in a bit more detail as we go through it. So here's the template. So I'll run through them now. So number 1, did the applicant do or fail to do something? Number 2, did this lead to them ceasing to occupy the accommodation? 3, was the accommodation available for their occupation? 4, wasn't it reasonable for them to continue to occupy the accommodation? 5, was it a deliberate or negligent act? And 6, was the act or omission made in good faith by the applicant, being unaware of any relevant facts? So as I say, I'm going to go through these in more detail. And again, if lawyers might say that actually this isn't the right order, that they would need to be looked at, and they're kind of, you might have some of the stuff in there as well potentially, but it's certainly in the ballpark of being useful. So then the first question there, did the applicant do or fail to do something? Now this really is identifying what was the reason that the person lost their most recent settled accommodation. So in Joe's case, it was the supported accommodation, or most likely the supported accommodation that he was living in. That would probably count as settled accommodation. In Kelly's case, the question would be, let's say she lost the accommodation from a private rented tenancy, something like that. So that would be her most recent settled accommodation. And so in Kelly's case, potentially the question would be, is she didn't pay the rent. So the answer to number 1 would be yes. The thing she did was she failed to pay the rent. We'll come back to later how that actually works in practice. With Joe, the thing that he did was urinated in the corridors. That was the deliberate act, or that was the act that kind of led him to lose his accommodation. So number 2, did this lead them to ceasing to occupy the accommodation? So in Joe's case, he urinated in the corridors. The supported accommodation therefore said he broke the rules, which he most certainly did, and therefore that was the reason that they then evicted him from it. And in Kelly's case, assuming that the rent arrears led to the landlord getting a possession order and evicting them through Section 21 or Section 8 potentially, then that would be the reason for them ceasing to occupy the accommodation. Number 3, was the accommodation available for their occupation? In most cases, the answer to this will be yes. So in Joe's case, he had no problem accessing that accommodation. It wasn't that he was locked out or illegally evicted. He could travel to it, presumably. Same thing with Kelly. Was she illegally evicted? Did the landlord change the locks? Was there a case of where she lost it because she couldn't travel to it? It's almost certainly going to be no in that case. So this is not going to be relevant in most cases. But number 4 is where things start getting very, very interesting. So number 4 says, was it reasonable for them to continue to occupy the accommodation? Now, in Kelly's case, this is where it could get interesting very quickly. So the question for Kelly would be, was it affordable for her to remain, to continue to live there indefinitely? And this can often be a case of, what's their income, what's their outgoings, and having paid the rent, do they have enough residual income to cover the necessities of life? And there's a lot of research that goes into this. The Association for Housing Advice Services, AHAS, publish research fairly regularly on this. They update it a lot. It's just been updated just the end of 2022, taking inflation into account. And so they kind of look at this issue of, how much do you actually need to pay for food? How much do you actually need to pay for toiletries and travel and clothes and white goods and all those sort of things? And in one sense, although doesn't become the law, it's very, very useful, and lots of councils will use that research. You can Google that as well, AHAS affordability research, you'll get the most recent version. And so the question in this case here is, once Kelly paid the rent, does she have enough money left over from her income, whether that's benefits, whether it's work or whatever, to actually cover those necessities of life? And again, the Department of Work and Pensions do a lot of stuff around reasonable living expenses as part of the amount of money they actually give to people. So that again is a very helpful source of information about this. But neither are kind of ready to go. You have to apply these kind of the principles and the figures to the person. So if you have a situation where, for example, they've got a particular medical condition that requires them to travel to hospital, and they can't, they have to pay for that, then that would be a part of those reasonable living expenses. So in Kelly's case, this is potentially the thing which is going to mean she is or is not intentionally homeless. If, having paid the rent, she does not have enough money to cover the reasonable living costs of her son and her daughter, then she cannot be intentionally homeless. And I'll say that again, she cannot be found intentionally homeless if it was not reasonable to continue to occupy the accommodation. And this wording here, if you're a bit of a geek, reasonable to continue to occupy accommodation is exactly the same wording that we see within the definition of homelessness itself. So again, if you see my videos on this, section 175 says you're homeless if you don't have a roof, you're homeless if you have accommodation but you can't get, it's not available for you for some reason. And crucially, you're homeless if you have accommodation, but it's not reasonable to continue to occupy that accommodation. And the way the kind of case law looks at that is reasonable to continue to occupy the accommodation indefinitely. So, for the foreseeable future. That's the kind of test. And so if you are essentially already homeless, so potentially Kelly might have been already homeless while she was living in this private rented tenancy. And therefore, although she deliberately didn't pay the rent, she essentially deliberately chose to pay for her family's food and kind of necessities of life rather than pay the rent. She cannot be found intentionally homeless because it was not reasonable to continue to occupy. So again, it may be that she's generally not intentionally homeless. The problem Kelly's got is that they've already found that she was intentionally homeless. They've said that she was, and she hasn't challenged within that time frame. So we're going to talk more about what she can do. Number 5, this is where it might be relevant for Joe here, although we're going to go to the Code of Guidance to get a bit more. The question here is, whilst the thing that he got evicted for was urinating in the corridors of the hostel, but he effectively lacked mental capacity at that point. And that's something I'm going to draw from the Homelessness Code of Guidance in a minute. So the question there is actually, although it is something that he did, it may not have been a deliberate or negligent act, in which case he would not be intentionally homeless. And again, number 6, was the act of remission made in good faith by the applicant being unaware of any relevant facts? It might be, in Kelly's example, that she was not aware of all the benefits she could pay for, or claim for, and therefore her income wasn't high enough to actually pay the rent. If she genuinely wasn't aware of it, then potentially that might be a good faith action to not claim it. There's been cases where someone loses their job, they fall into rent arrears, and they simply don't know about housing benefits, so they kind of they can't be blamed for not claiming it. But that's a little bit different. Whereas if they did know about it and they just didn't bother to claim it, that would be a problem. That would probably mean that it would not be classed as a good faith action. So, as I say, this is the kind of wording that the Bedford Borough Council use. Your local council will use probably something similar. They might kind of change the wording of some of the steps. One thing that this template doesn't really spell out here is that it is the applicant's actions. That's really important. That's going to come in handy for Kelly, because essentially there's no such thing as an intentionally homeless household. You just have whether the individual who is approaching is intentionally homeless. And this is where we kind of get to this word of acquiescence. And acquiescence is this fancy word within housing law, which basically means, did other household members know about what the tenant was doing, and did they acquiesce in it? Did they kind of go along with it? And this could save Kelly's bacon, because in a sense, just because the council's found her intentionally homeless and that review period has now expired, there is nothing stopping her 21-year-old son approaching the council in his name with his mum and his sister on the application and making the application that way. They could certainly trigger section 184. This would count as a new fact which would enable them to go to the same council. And the question, and the important thing here is that the council can default assume that everyone in the household acquiesced in the behaviour, in the actions of the tenant who lost the property. I'm being a bit clumsy of how I say this, but hopefully that makes sense. And so it's important in this son's case that he does very clearly say, I was not part of the financial management of the house when my mum got evicted. He has to say that. It's important that he does say that, otherwise the council can just basically assume that he was part of it. And on saying that, the council then need to look into the facts of the case and say, okay, was he aware of the finances? Did he understand about, the kind of nuts and bolts of paying the rent and all that sort of stuff? And if he didn't, if he was not part of that financial management of the household, then potentially he would not be intentionally homeless. And that's probably the best way for this family to proceed, is to apply to the same council, but do it in the son's name. Then if you have a really difficult council, the council might say that he doesn't have mental capacity to make the application. That is highly unlikely not going to be true, but you might have some councils throwing that sort of stuff. There's some councils seem to see a mental health issue of some sort and immediately conclude that you don't have mental capacity to make an application. Mental capacity is something that anyone can assess, but it's always decision and time specific, and essentially the adult son would need to understand, he would need to be able to express, where he wants to live, what type of accommodation he wants to live in, those sorts of things. He would need to be able to instruct people to help him out. as most people with autism would be able to do. And he would need to understand that, he needs to pay rent in order to satisfy the conditions of a tenancy. He needs to, behave in a certain way to meet the conditions. But it's highly likely that he would have mental capacity to understand all of that, and therefore he can make the application. Now, I'm going to keep going with Kelly for a second, because that's option 1. Option 2 would be for Kelly to approach a different local authority and make an application there. There's nothing stopping her doing that. She can approach any local authority in the country. But by doing that, and this is something which has come up in the comments section as well, by somebody who kind of pointed out that was actually not right about something here. She could go to any council in the country, but by doing that, she's basically gambling that the housing, the housing officer that deals with her from that other council is going to take pity on them, because what they could do is they could put the family in temporary accommodation. They could, finish their inquiries. They could issue a Section 184 notification saying, they're in priority need, and actually we don't think they're intentionally homeless. And they could then refer them back to that first council, and that first council can't really refuse. Now, as I say, that's really relying on kind of falling on the mercy of that housing officer, because what they can also do, and I don't think there's any guidance saying which one they should do, but they could also refer them back at the relief stage before they actually reach that decision. And in one sense, that means that it hasn't really worked, it hasn't achieved that. So although technically you could do it, technically she could apply to lots of different local authorities and hope that one of them takes pity on them and and acts within their powers and their duties to get the family housed. You can't make the council do it, and equally you've got this other problem where you could actually approach a different local authority and they choose not to engage with Local Connection at all, and they end up offering you accommodation in that other area, which might be the other end of the country for all you know. So yeah, there are problems with that. So if I was in Kelly's situation, I'd be getting the son to make an application to that first local authority, making the application in his name. The difficulty, the other kind of complexity with that for him is that he needs to have someone on his household who has got a priority need, because unless he provides kind of some sort of parent-child type relationship with a sibling, which is possible, but it doesn't sound like it's likely in this situation, he's not going to be able to get priority need status through having a dependent child on the household. There's a bit of a weird kind of aspect of housing law that, but potentially his autism may well mean that he is in priority needs through being vulnerable as a result of the kind of effects of his autism. So again, I've done videos on how that might be assessed, but that's something that that's certainly the option. That's what I would be saying to this person in this situation. Kelly, I'd be saying to her, go make an application, get your son to do it. I've certainly done that approach with Bedford Borough Council before, and actually that was made even easier in that case because the adult son, it was almost identical situation to this actually. The adult son did provide a lot of care to his siblings because his mother was unwell, and so they were technically dependent on him. He was doing the school run with them, he was doing the shopping, the cooking, the cleaning, that sort of stuff. So that was kind of how we got around it in that situation. So that's Kelly, that's what she can do. The key thing there is, was she actually genuinely intentionally homeless? Was it reasonable to continue to occupy the accommodation? But I'm just going to go to the Code of Guidance for a second, just to draw out a couple more paragraphs. So it's all in Chapter 9, as I've said before, and I'll just kind of reiterate some stuff which is, hopefully I've said, but I'm going to try and go through it again anyway. So 9.7 of the Code of Guidance, Section 191 of the Housing Act, Part 1, subsection 1, provides that a person becomes homeless intentionally if all of the following apply, and it has to be all of them. That's the key thing here. So A, they deliberately do or fail to do anything in consequence of which they cease to occupy accommodation, and the accommodation is available for their occupation, and it would have been reasonable for them to continue to occupy. And that's why I'm saying, for example, just give you a silly example, but actually something I've seen in my casework. An individual subject to domestic abuse, she chooses to flee, and the council therefore say that she's intentionally homeless because she chose to flee. Now, obviously legally that's nonsense, because the key thing there is that although she deliberately fled, it was not reasonable for her to continue to occupy that accommodation because of the domestic abuse. In one case, not too dissimilar from that, the housing officer even recorded in their notes that although she was subject to considerable abuse, if she left the property, she would be making herself intentionally homeless, and that was a nice, easy compensation claim. So that's 9.7 of the Code of Guidance. But in terms of, for Joe, there's a bit more stuff that's going to help us out here. So if we go down to 9.17, generally, an act or omission should not be considered deliberate where, for example, A, the act or omission was non-payment of rent or mortgage costs which arose from financial difficulties which were beyond the applicant's control, or were the result of housing benefit or universal credit delays. That's, shouldn't be too controversial, that's pretty obvious. B, the housing authority has reason to believe the applicant is incapable of managing their affairs, for example, by reason of age, mental illness or disability. Now, As a bit of an aside here, notice that the inability to manage someone's affairs, or being incapable of managing their affairs, is not the same thing as not having mental capacity to make a homeless application, because the fact is, in chapter 9 of the Code of Guidance says that it assumes that people who may have difficulties managing their affairs will be making applications, potentially will have become homeless, will be making homeless applications, and in that case they may well not be intentionally homeless. So just as I say, a bit of an aside for those areas where the lack of mental capacity to make an application is used quite frequently. B, and by the way, so with Joe's case, that may well apply here. So one sense of he's alcohol dependent, he's got bipolar affective disorder. It's possible, well, it's not definite, but it's possible he was not, he was just not able to manage his affairs whilst living in the supported accommodation. But then C, the act or omission with the result of limited mental capacity or a temporary aberration or aberrations caused by mental illness, frailty, or an assessed substance misuse problem. So again, being blind drunk is a mental capacity issue. It certainly can be, although ideally you want to be assessing that at the time. But clearly what's happened here is he's got evicted because he was very, very intoxicated and he's urinated in all the corridors of the local supported accommodation. And clearly there's going to be a good argument here that actually when he did that, he was, he had a temporary aberration of his mind caused by an assessed substance misuse issue or misuse problem. And this is actually a case I'm, based on real life. This was a case I got overturned and actually got the council to agree that he was in priority need and he was not homeless intentionally, because there, whilst he did something which probably was quite right to be evicted for, he was not responsible for it in that kind of way. It was not a deliberate act in that way, because he had this fluctuating mental capacity, because he had this difficulty managing his affairs, because of the substance misuse issue, because of his bipolar affective disorder as well, kind of combining. So yeah, he was not intentionally homeless. So that may well be the thing. There's a few other bits I'm going to go through as well here because it's also helpful. So D, the act or omission was made when the applicant was under duress. So this would cover where someone is basically being cuckooed or exploited or potentially subject to domestic abuse. Again, I've seen cases fairly, not infrequently where that's been the case, where they've been blamed for drug dealing. They lost their accommodation because of drug dealing, they got convicted, but it later turns out that actually they were being cuckooed at the time and forced into that activity, and therefore they could not be found intentionally homeless for it. Having just mentioned prisons, or prison sentences, in a lot of cases, people who lose their accommodation because they get convicted and because they go to get a custodial sentence would probably be intentionally homeless. It's not that they intended to be homeless, it's that they intentionally did something which could foreseeably lead to the loss of their accommodation. But you still need to apply this test. It would still need to have been reasonable to continue to occupy. So even if, I give this stupid example, even if you got evicted because you punched your landlord in the face, which was, among other things, a criminal offence, if that accommodation had not been affordable for you and therefore not reasonable to continue to occupy indefinitely, then actually you would not be intentionally homeless. And that, in one sense, that kind of, it might not sit right with a lot of people, but that's what the law is. That's how it should apply. In one sense, the law really around intentionality is basically trying to make it so that people don't knowingly worsen their situation to jump the queue to get housing, because if you're homeless you tend to get treated with more urgency. And so really what the law was designed to do is to stop people abandoning their home and then therefore becoming homeless. It might be they've got a priority need, so they then get to the top of the housing register queue. That was really the point of it. So and often what tends to happen is that housing officers apply a kind of a test of morality. Did the family kind of do what they thought what they should have done? And actually that's not part of the test. The test should be a very objective, could they afford the rent? Did they have enough money for the necessities of life? And even if they were, even if they had a drug or alcohol habit, that doesn't necessarily mean that, just the fact that they were spending money on drugs rather than food, that doesn't necessarily mean that they're, that the calculation changes at all. A few other bits from the Code of Guidance I'm just going to read out, or we'll show you on the screen as well. So the Code of Guidance also gives some examples of situations which are likely to be regarded as leading someone to be intentionally homeless. So 9.20, paragraph 9.20, examples of acts or omissions which may be regarded as a deliberate, unless any of the circumstances set out in 9.17, which is what we just did, include the following: where someone A chooses to sell their home in circumstances where they are under no risk of losing it. So, and that infers that actually if you sell your home because you can't keep up with mortgage costs, then you wouldn't be intentionally homeless. B, they've lost their home because of willful and persistent refusal to pay rent or mortgage payments. And again, the inference there is that it was affordable for them to pay it. C, could be said to have significantly neglected their affairs, having disregarded sound advice from qualified people. Just something I haven't actually said yet. So I've worked with hundreds of people in my casework. I've only worked with like 2 or 3 who are actually genuinely intentionally homeless, so you could actually say, were that uncooperative or that unreasonable to actually satisfy these tests. D, voluntarily surrenders adequate accommodation in this country or abroad, which would have been reasonable for them to continue to occupy. And just as a thing here, actually, just to say, is that you will sometimes have people who abandon their property, and actually when you look at the facts, it's because their mental health was in such a bad way that they felt they had to. And again, that would potentially mean that the accommodation was not reasonable to continue to occupy, but you need some pretty in-depth, detailed evidence from mental health services or something, just to say, actually, in one sense, yes, they did abandon their property and that led to them losing that last settled accommodation, but they did that whilst their mental health was in a very poor state. So they weren't really they weren't managing their affairs, or they weren't functioning in any kind of meaningful understanding of that word. So that's something that could come in. E is evicted because of their antisocial behaviour, nuisance to neighbours or harassment. And F is evicted because of violence or threats of violence or abuse by them towards another person. Now, often you're going to work with people, if you kind of work in a sector where actually you're working with perpetrators of domestic abuse, or you're working with perpetrators of antisocial behaviour. Now, my view is that no matter what you've done, you should be treated according to the law. It may well be the right thing to do is for that person to go and be sentenced to a custodial sentence or something. But ultimately, they should also, if they're going to be convicted under the law, they should also be supported under the law. That's the way I see it. So you're going to have people sometimes who genuinely will be intentionally homeless because of the fact that they committed some sort of antisocial behaviour or abuse, and that led to them losing that accommodation through a non-molestation order from the courts or a bail conditions or something. But if they have a priority need and if they are eligible for assistance, they may well still be able to get housed for 2 or 3 months by the local authority, which will, nothing else will give them opportunity to find something else. And ultimately, there's a pragmatic argument here as well, in that if you don't help that person out, it's almost more likely that they're going to go and cause more trouble to other people, or potentially the victims they've already abused. And there's often something said within domestic abuse work where it's often the victim who has to go and relocate. It's the victim whose lives are disrupted. Whereas sometimes you might be able to find alternative housing options for the perpetrator, which actually means that the victim themselves are going to be able to continue living in their own home and kind of make a fresh start. And hopefully you can get that perpetrator out of the picture. And then G, leaves a job with tied accommodation and the circumstances indicate that it would have been reasonable for them to continue in the employment and reasonable to continue to occupy the accommodation. Now, I remember working with a pub landlord who'd basically been sacked because of some sort of financial irregularity. Essentially it looked like he'd been pocketing cash. So although he didn't intentionally become homeless, he did intentionally do something which was likely going to lead to him losing his job, and that in turn was likely going to lead to him becoming homeless. So that's kind of how that might work in practice. So now, so I'm hoping that all of that's helped. I'm hoping it kind of made sense. In summary, what Kelly would need to do, this hypothetical Kelly, she would need to essentially most probably get the son to make an application in his name with her and the household and the sister on the application, and they would need to make it clear that he was not part and parcel of the financial management of the property that they lost, and that he has, or someone else in the household has got a priority need, which would basically mean the council would then have a main homelessness duty to them. And in Joe's case, he should make an application to the local authority. They're going to have to put him in temporary accommodation anyway, because he's obviously going to be in priority need with those diagnoses and the substance use issue as well. And then probably an advocate would need to make sure that the council is properly considering the impact of the substance misuse, the impact of his mental health condition on his ability to manage his affairs, and then most probably that's going to lead to a decision that he's actually not intentionally homeless. And again, that was based on a real case where that's exactly what we did argue, and the council then owned him the main homelessness duty. And actually, so yeah, hopefully that all helps. I'm hoping there's a bit more information there. Again, if you want to know more, go to the Homelessness Code guidance. The whole chapter about it is really useful. Ultimately, the key thing I'd say is that, number one, Don't assume that a council is actually right when they say you're intentionally homeless. In my experience, most people who are told they are intentionally homeless are really not when you look at the facts and the technicalities. And two, make sure you challenge those decisions within 21 days of receiving the letter. If you don't, you could well fall foul of essentially a decision which becomes set in stone, even if it's actually wrong. And in terms of what you would do, then there is a possibility that if you were to trigger a fresh application subsequent to that intentional homelessness decision, and in that fresh application you gave them information which they were just not aware of when they first made that decision, or they ignored that first decision, you technically could get a second application triggered, but it's quite difficult to do it that way, so it's not recommended. You want to really just be getting on the, getting in contact with a solicitor or something when you receive the intentional homelessness decision, to try and fight it in those 21 days. So yeah, if you find this stuff useful, please do like and subscribe to it, and probably more importantly, send it to anyone who might find this stuff useful, because ultimately this is about trying to get the right information to the right people. So keep the questions coming in the comment section. I will try to get some more videos out in the near future. It actually ends up taking quite a lot of time, but as I say, hopefully that's helpful. And if you do work in the homelessness sector, we do run online training courses where we cover exactly this type of material. It gets really good reviews. We kind of also deliver it to teams all around the country, ranging from social services, street outreach teams, police, all sorts of different people. So again, it's kind of stuff which is ultimately going to equip you to make sure your clients are getting treated lawfully and getting housed, and actually make your job much easier as well as their lives. So yeah, hopefully this all useful stuff.